akkiriza babulijjo bagoberera ensalawo so bwekyo embeera bwekyali embeera ya bukakamu obutafaanako namulundi guli ewandi security y'amaanyi era butabusinga bannamateeka mukwano gya eronikiza oteeka n'abamu ku baclientsbe kitegeddeko nti abamu baclientsbe bazze okwinira naye solidarity nga agezaako kubanira so bwekyo bwe tuli so okulaba nga obaolyawo tulaba gye binalubeera naye bakigamba nti tunaluwulira ebiseera ebisinga tutera kubyukirira naye ffe babisaze okuzibuukire tetulinze kubuuza nti ezinga bwewange ebiseera ebisinga atera kutwalira kusiba emmere so bwekyo bwe tuli wano nze mukose so okulaba nga mbawa updates oba okubagezaako nga bwe bigenda amaaso nkulu eye civil division oba ebuuza emisango egy'omugaso egitali gya naggomola so tuli era ku floor eyokuna wali courtroom eri courtroom naye nga room 1 of first floor naye nga room 16 kooti eri courtroom 1 naye nga bizimbe room 16 so ekyo embeera okugiriza so olaba nga oba oliawo balaba ye kanso Benjamin Katana wa National Platform mukwano gwa Erikiza naye ali wano nnyo okulaba nga oba oliawo alaba abigenda amaaso mu ggwanga kutegeeza nti wasinga okuba bannamateeka mukwano gye oteeka ne baclients abamu bazze maybe ne bannamawulire bo bangiko sobolaba nga nabo bagoberera n'okwagezaako ensonga zino ngabo ziri okuba mu gy'amawulire online gy'empapula eza radio tv so bonna bali wano sobolaba ye kanso ye honazaakipasite ye agumbidde ddala wano eyeenyeenya tavaawo yagamba nti keetonye kwake alina okuba wano ng'ategedde ge ate n'amateeka feeti yeebwere so maani nnyo era nga teyeenyeenya kasibuka okuba ntulaawo talinavaawo okweyagala noba nga abagulawoko nayagala apipigeyo oba alinzeeko alabe kiki ekigenda mu maaso bagezaako okulaba defiantly bagezaako okuaccessinga basokita bannamateeka kitegeeza bagenda mu kale abalabi bange mberekereza nja kubaddira nafunye esomera ezisembaku ezo okwogerera tewannabaawo kirala kyonna kijja okujja bannamateeka badde bagezaako okumugoberera naye bategeeza nti atemukutabuti agenze kwetawuluzaamuko akuma babadde balowooza nti oba oli abamukusa bamutwala chambers naye nga nabategeeza nti ageza okufulayo okutaano so nga bwabuna misiri gy'abannamateeka bageza kubanga badduka bamukukusa omuntu bamufuula eyokutaano babadde bamukusa nga tebategedde nti akukusibwa paka kufuula eyokutaano so ono era nga gino emisana gyolaba gyabannamateeka n'aboluganda okusobola abantu baakiseesinga okubanga mulabako babadde bamukusizaako nga tebategedde naye nga togera fulo eyokutaano era nga tubadde tugungumanyidde okufula eyokuna ne bagezaako okumukukusa okumeta mu fula eyokutaano ne bababugulizaako nti mukyali awo mandiba nga mukuma lubugo nga temukyali waliwo so kanasala naffe yugayo namukwasa fulo eyokutaano oyo amateeka emikiza okwange This side is men alone. I don't want to go on my side. You may keep my father, you can come. Yekanso ebonekeza natuusibwa kooti okulaba nga tunaaluliriye kanso Kanso eyonekiza omulaba nkozeemuko naye nga waali nnyo osooka banga afuna ensawo y'omulamuzi lunaku lwaleero naye nga bannamateeka bagamba nti beetegefu oba eyosaidi yaabwe tekusaidi yaabwe bo beetegefu okulwanira eddembe lye ekyokulaba ng'afuna obwenkanya nga bwabwagala era nga bwabulwanira nga bagamba nti oluvannyuma lwa kkooti ensukkulumu okugamba nti kkooti y'amagye yaliwo omugenyi w'amateeka bagamba nti kkooti eriwo omugenyi w'amateeka tasobola kusalira muntu musango ng'ate yo teriwo mateeka so nga bagamba nti omuntu omufu tasobola kusalira mulamu musango so nga yeggwanga tebatudde ekyokulaba nga oba oli awo bali wano ekyokulaba nga bafuna ensawo y'omulamuzi naye omulamuzi y'omu application yeefaananyiza ng'eno akawungezi k'eggulo yagigobye eyabadde yakawunti okutakiriza Besigye ne munne Hajji Obed Lutale babadde bagezaako okufuna obwenkanya era nga bagamba nabo bali ebizira mu bukyamu. Omulamuzi kyeyagambye nti si kituufu kubanga yakizudde nti waliwo emisango emirala egyabagguddwako mu kkooti enakawa n'olwekyo bo ebizira baliyo mu butuufu olw'okuba nti waliwo emisango empya egyabagguddwako naye ate yo naye Eron kyayawula mu kkooti kubanga ye yasalira kkooti y'amagye ate kkooti ensukkulumu gye yagamba nti teriiwo mu butuufu bwayo so katuunya tulabe bo omulamuzi ono y'omu kikyasalawo olunaku lwaleero ku nsonga eno. Awo abo abamu ku basirikale abamulumiriza era nga sipiriti ya prison yo eri gguluggulu wabweru y'omunda. Kati tulina mulamuzi abe ng'ayingira so yo kkooti yatudde dda. Mugaye era katwegattako tuli wano tulinda nsawo y'amulamuzi endagala sikiriza era nga kkooti yo etudde okusobola okulaba nga bafuna kanso erekeza afuna looling. Mu kusooka babadde tebagala kugibawa, bagamba tajja kugibawa ng'ayita ku email kuba abuuza bannamateeka abaakeddewo kiki ekyabadde kibaleese ne bamutegeeza nti bakimye looling. N'abuuza nti byabadde awalungi y'abeesigye yabayise. So defiantly bannamateeka ne bagamba tujja kuvaawo nga tufunye looling. Oba ogiweza ku email naye twaga email nga tuli wano. Naye ate oluvannyuma ennyo kitegeezeddwako nti Aaron Kiza abadde ali mu kkubo era bw'atuuse omulamuzi Singiza kigamba nti abadde yeekwese mu office ya registrar, naye Aaron Kiza bw'atuuse registrar n'amugamba omwai genda mu kkooti kubanga omusibe waba atuuse aba alina okufuna ruling ye. Bwe butyo defiantly bannamateeka oluvannyuma okulemerako kakkana nga omulamuzi akkiriza agende mu open court kyokubanga awaloading as opposed ku email gy'abadde proposed mu kusooka. Tuli wano tumulinda tulabe obanga ajja awaloading eyo oba naye nga bannamateeka bagamba nti yonna loading w'enaabazze website yaabwe oba website yaabwe bo beetegefu era nga kyaba kizeeko kivudde mu loading eyo bajja kyambala nga bwe kinaaba kizze. Naye nga ye Aaron Kiza awakanya okuba nti yasalirwa era nga asaavinga sentence mu kkooti etaliiwo oluvannyuma lwa kkooti ensukkulumu okugamba nti eno kkooti y'amagye terina buyinza buwozesa misango nga konvikitinga muntu nga Aaron Kiza. So Aaron Kiza agamba nti ekibanja kkooti entuufu ate lwaki mbeera mu kkomera oluvannyuma lw'okuba nti eno kkooti yo akufu. Omulamuzi yagamba nti oyo yenna eyajulira ng'awakanya ensalawo ya kkooti y'amagye wadde okugenda mu kkooti eza bulijjo okusaba remedies oba okusaba kugondezebwamu n'okuyimbulwa. So Aaron kuno kwe yasinziira n'ajja mu kkooti eno okusobola okulaba nga oba oli awo ayagala ofuna eddembe lye naye ali obutaala nga nsingo ya nkoko. So bwe tutyo bwe tuli okusobola okulaba nga oba oli awo tugoberera n'okulaba ki ebinaaba ebivudde mu kusalawo kw'omulamuzi. Tetumanyi lwaki omulamuzi akyaluddeyo okuvaayo naye nga bo bannamateeka ab'emikwano n'abamu ku batayambisibwa Kiza bwe bali nnyo okusobola okulaba nga oba oli awo bafuna luuligi yonna nga bwe naaba eyise. So tubeebaza gwe wena wenna akyalemeddeko tukusaamu ekitiibwa n'okukaddatako k'otuteekamu. Weebale nnyo, weebale ddala okubanga otuwadde obudde ne kaddatako okusobola okulaba nga okugoberera embeera nga bw'eri. Nze mukusse Anode Anthony, tuli butereevu ku Alternative Uganda Facebook page, TikTok TV Facebook page ne Alternative Uganda YouTube. So ogenda ku website yaffe ku www.alternativeuganda.org osobola nga ofuna empeereza ez'enjawulo www.alternativeuganda.org osobola okufuna empeereza zaffe ez'enjawulo. Oba osobola okukyalako ku ofiisi zaffe awo ku Limanganda bw'oba ova sayidi z'e Makindye nga wakayisa ofiisi ya NIRA ey'e Makindye era nga twashifutinzeemu okuva we tubadde mitaazi 5 okutuuka wano awala tuli ku 15S 15C ku Setenda Lane ojja kubanga otulaba 15C ku Setenda Lane ojja kubanga otulaba location eno mpya mita ziri nga 5 okuba tubadde awakadde so tekijja kubalubiriza nnyo just nga wakayisa katono nnyo ku ofiisi ya NIRA obadde ova Makindye wetubadde obadde osooka wafuna okudda ku ofiisi ya NIRA naye kati otazze osooka ofiisi ya NIRA n'olyoka odda ewaffe kubanga ova sayidi za Makindye naye nga ku mukono gwe gumu ogwo oluguudo oluli e Makindye oludda e Buziga Munyonyo. So kubanga nawo otufuna obulungi nnyo nnyo ddala twinawulo ku Limanganda so okujja ku ofiisi yaffe n'osobola okulaba ofuna empeereza zaffe oba n'okwebuuzaako mu mbeera ez'enjawulo. So tuweeza message ku soga mu inbox ya pages ezo ez'enjawulo ojja kubanga osobola okuba nga ofuna oba nsobola n'okutubirako ku ssimu 0784 first of all ya Airtel 0702 976 ojja kubanga ofuna obulungi nnyo nnyini ddala naye nga tukyagenda maaso yagendako omulamuzi okulaba nga ajja omulamuzi Douglas Liza naye nga yo kooti yatudde dda okubanga efuna ensalawo ey'omusango gwawabirwa Kiza nga yeekubira enduulu nga wakanya okuba nti aholdingibwa oba asibibwa ekitali obumenyi bw'amateeka oluvannyuma kkooti ensukulumu okulagira nti ono gyali aliyo mu bumenyi bw'amateeka. Ekyenjawulo kya mulamuzi ono kubanga tugamba yagala kifaananyi kye kubanga kirabika So naye eddoboozi tuyinza okuba nga tulifuna eddoboozi tulifuna naye nga kyo ekifaananyi tuyinza okagifuna kubanga ebiseera ebisinga ayagala nnyo okulabikira ku mitimbagano oba ku mikutu gy'amawulire okuggyako ngaobalaya naaba akikkiriza naye omulundi ogulwadde twasembayo nga tugaaniddwa okulaga ekifaananyi kye naye nga tuliwa tulinda eno This is the business code number 33 in 2025.
Yes. Like I requested last time, please, and I do this for the security of the presiding judge.
This is business code number 33 of 2025. Uganda Society as the specifically prison and the attorney general.
It says ignore it.
We ignore this one.
Yes.
My Lord, if it pleases court, Peter Muchiti Warupiri. I am appearing with my land friends, George Musisi, Kunihira Proscovia, Katot Musime, Kenneth Muhanji, Benjamin Katana, Suleiman Kakaire, and Tobias Afuswa Edwin for the applicant. And my land friend, Nakwera Johnson, appears for the respondent.
The record is being captured.
My Lord, these matters have been reserved for, I think, a ruling. We're ready to see what's ruling.
Okay. Before we come to the ruling, because I just wanted to confirm whether all the directions were complied with as given last time. I think we start from there. Maybe you can address us on that.
My Lord, the directive was to serve all applications on the Attorney General. The last time we were in court that day, we did service. For the applications that the Attorney General had not filed the affidavits in reply, he was to file latest the following day, and all parties were then supposed to file submissions. We did comply for the applicants. I've not seen some of the submissions from Attorney General in some of the applications.
Okay.
But the timelines were fixed.
Good thing he's here with the assessors. AG, what did you do since last time?
Johnson Atwere is my name. For record. Your Lordship, you gave directions, and you indicated that the directions you gave, and you were in response to my clarification, that they concerned to the applications that had been filed and served on us. And it was only number 33 of 2025 at that time that had been served on Attorney General. And you gave directive that by close of that day, we should have filed a reply, an affidavit in reply, and the following day, all parties should have submitted submissions.
That is 33.
33. The following day, we complied with the orders of court, and we filed our affidavits in reply and submissions for number 33. The following day, we checked on FMS. The only documents we could find were only affidavits for number 37 and others which had not been served on us. We could not reply to affidavits because we didn't know, they did not contain the notes of motion. Yesterday, we got number 37 and we did a reply. Today morning, we filed the same on ECMIS in response to number 37 of 2025. The rest we have not, because they have not been served on us. One common denominator, my Lord, is that they look similar and the orders they are seeking are the same for number 33 and number 37. I don't think they would even need, as you had guided before, that you would look at whether you can or you may not consolidate them. But I think, in my opinion, is that the remedy is the same. There's no need even to give it any other day. And our submissions would be adopted for the same. Thank you, my Lord.
So that explains why, as a judge, I was still not sure what was happening. And that's why I had initially dodged you, because I could see in the system that the directions have not been fully complied. So we agreed now, all the pleadings and arguments are in.
Yes, ma'am.
Okay, I think we are good to go. For me, it is always better not to rush a ruling like this. So if you give me at least 4 days, I should be able to come out with a decision. So tentatively, that makes it well, my clear. Wait, I'm coming. Okay, Monday. Okay, maybe let me first. Yeah, fine. Okay, let me first ask Mr. Walubidi. Supposing we assume that what was argued and pleaded in 33 covers 37 or any other related application. Can you, because I've looked at your submission, you talk about two main issues. You could address this court on only the first issue, then so that I can understand your mind better. I don't want to second guess your key argument on issue number one. I know you can do it better. All the facts are known to us. We have read and understood them. So what argument are you making?
The basic argument, my Lord, we're making is that the applicant, Council Aaron Kiza, was subjected to contempt proceedings before a court which the Supreme Court has found to have no competence and jurisdiction. Given its composition, its mode of appointment, and the many other reasons that the Supreme Court determined. The Supreme Court then held that where proceedings before the General Court Martial have been challenged, the decision of the Supreme Court nullifying the proceedings before the court martial would have retrospective effect.
Last time, I appealed to lawyers to break it down so that people can understand what we are. It could be an easy English word for you. For
Yes,
all
I will read from the decree of the Supreme Court.
Okay, but you can simplify us.
Yes, I will. In the second order of the Supreme Court, the court held that all charges, ongoing criminal trials, or pending trials before the courts martial involving civilians must immediately cease and be transferred to the courts of law with competent jurisdiction. That meant that anything going on in the court martial involving civilians would have to terminate in the court martial. And possibly, if it was possible, transfer it to civilian courts.
So, just realistically, which court do you think at that point the Supreme Court probably had in mind? A civil court or a criminal court?
If there were criminal trials, then they would go to the criminal court. But my lord, the point I want to point out is that in practice, there would be no transfer. We had the most recent experience involving Dr. Mesije and Ajutale. acknowledge, and I think my lord, you have taken traditional of it, is that they have been charged afresh because it's not possible to transfer. You will have to, if there is some evidence that the DPP considers worth of a charge, to start de novo, as has been done in the case of Dr. Leslie, his OR2. Now, my lord, the most critical and applicable aspect Council Ellen Kiza is order number 3 of the Supreme Court. And I will read it. It's a short one. It says, this judgment shall have no retrospective effect on any convictions made and sentences imposed prior to the date of this judgment, save where the conviction and sentence is being challenged in a court of law.
Okay, and that's where I wanted you to help us. Because that order seems to have two legs, so to speak. Yes. So the first one is what do you think, in your view, the Supreme Court meant when they said no retrospective effect? We can start it from there to break it down for the media and therefore members of the public.
Not having a retrospective effect means that convictions and sentences that had been imposed by court martial on civilians would stand, they would not be nullified. That's the first thing.
Okay.
However, that's why they use the word say.
Yes.
However, where those convictions and sentences were being challenged, then the judgment would have the retrospective effect of nullifying what the court martial had done.
Okay. You know, last time I told people you are my former teacher, and I'm happy with that. So I don't want to say please stop there, but I can request you to hold on a little bit, and I can share this experience. When I was a chief magistrate, I would deal with the applications for revision, where an LC1 court had convicted people, in offenses of defilement. They would have a judgment. So whenever those decisions would come to me, just one paragraph, I would say no jurisdiction, cancelled. I wouldn't go into all those details. Now, in the same way, why I'm raising that question using that example is this civil court the right court in terms of order number 3 of the Supreme Court to give the correct reliefs? Wouldn't it be possible that probably a criminal division judge would look at this judgment of General Court Martial and then 2 lines quashed?
I got with respect, there is no necessity for the nullification of the judgment of the court martial or to the Criminal Division of the High Court. Lord, under Article 139(1) of the Constitution,
Article 139.
139,
Yes.
I think, Clause 1 of the Constitution. You are seated with unlimited jurisdiction, including the jurisdiction to put in effect what the Supreme Court ordered. Namely, that convictions and sentences that were imposed by the General Court Martial on civilians, contrary to the proper interpretation of the Constitution, are null and void if they are being challenged.
Let me also give you another example.
So it is my submission is that this does not require, because you are not now going to try
Yes.
Aaron Keys.
Yes.
You are simply declaring his right, and it's the civil division dealing with right.
I hear you, Counsel.
Just declaring his right, that whatever was imposed on him, this is challenging it, is a nullity, should be set free.
Let me give you another. Let me tease out another example, quick one. Honorable Kahonda had an electoral dispute in Mitoma district. He filed an application in Tororo, and my brother, the late judge, took the view that as a high court judge, we have floating jurisdiction, that you can sit anywhere and handle any matter, because so when you took that line, I remembered that decision of our brother judge. He passed on. So is it your case that wherever a judge is, he can entertain any matter regardless of the divisions that we have in this country or the circuits that we have?
Divisions are administrative conveniences. And you only operate, for example, in Kampala. I don't know if you are seated in Masaka, you'll be handling land matters, you'll be handling criminal matters, you'll be handling civil matters. I'm not so sure, but I've argued that you should be even handling labor matters in spite of the existence of the industrial court. Because they expect one industrial court in Uganda to handle labor matters in Karamoja, in Kotito, in Kabale. It's not administratively convenient. And my lord, we are dealing with the right and the liberty of a person in this country. His liberty cannot be the subject of administrative conveniences. At the earliest opportunity, your lordship seized with unlimited jurisdiction. Is my humble prayer, duty bound.
I've heard you now.
To give effect to the judgment of the Supreme Court.
I've understood. Now I've got
it. In fact, my lord, there were attempts to file these matters in the criminal division. And on Ekimis, the registrar in the criminal division purportedly even dismissed.
okay, that one is valid.
So So really, to toss this.
No, I get you. Do you have evidence that you filed and the registrar decommissioned the file?
Yes.
Yes,
Yes, I wish I can have that because then you can help this court.
Shall supply. Shall supply. My land friend, Mr. C, can say more on that particular matter.
Yes, my lord, regarding that, when we filed the matter in the criminal division, which we are going to supply to court, we even met the head of the division, and he brought to our attention a decision of that court that any matter involving Attorney General should be filed in the civil division. And that informed the registrar's attendant decision to decommission.
Yeah, and which now makes it now a little bit different, because had you filed, for example, an application for revision, because the revision you are seeking to formally nullify everything that was done, because and you don't need so many paragraphs. Maybe we shall have a discussion.
I'll just put it on your record. It's miscellaneous clause number 20 of 2025.
Speak to the microphone.
It's Aaron Kiza versus the Attorney General, miscellaneous clause number 20 of 2025.
Yes.
Which was filed in the criminal division.
And the key reason given was that for as long as there is the AG
as a party, then
the criminal division cannot entertain.
Yes, my lord.
Which means if you had not included the AG, probably they would have given you audience. That's what I'm trying to.
Well,
yeah, but you see, my lord, the AG is the representative of the authorities that are holding Mr. Aaron Kiza in prison. You can't really have filed this matter without the Attorney General's involvement.
Yeah. I agree. Okay.
Wouldn't want to come and then they say, but why didn't you serve Attorney General? Why did you, who will speak for the prison authorities and so on?
Yeah.
So the matter, my lord, is properly before you.
No, the rest of the arguments are very clear. No, that's not. Mr. Warzidi has really done it. So the rest, you are now going to speak good English.
No. I would just like to just mention something.
No, it's okay.
Just copy that.
AG. Okay. The reply. What is your argument? In the file where you replied, just 2 points.
Your Lordship, the facts of the
Go
case,
back on record for our transcriber.
Johnson Atwera, I'm a senior state attorney. The facts of this case is that my brother, Mr. Aaron Kiza, an advocate of High Court and all courts of judicature in Uganda, was accused of contempt of court in the General Court Martial.
Which court is no longer in existence?
Not at all, my lord. It is in existence.
Okay.
The Supreme Court did say that the General Court Martial is a court of law under the Constitution of Uganda.
Now that's the point I wanted.
Yes, it did not abolish it. It reaffirmed its existence, but only limited it to specific cases of offenses relating to military service.
How about the way it was constituted?
The Supreme Court gave advisory on how best it can be constituted, but it did not give orders. Yes, my lord. So Mr. Kiza Aaron was accused of contempt and was tried and sentenced in accordance to Section 169.
What is the sentence under the law?
That's why I'm coming to, my lord. Under Section 169, 1G, it relates to contempt of an advocate. And when you read it in relation to section 2129 of UPDF Act, it says it gives an advocate who is charged of contempt before the military court of a maximum sentence of 5 years. The sections
Not 1 month.
Not at all. Maximum 5 years. I want to believe that my former professional advisor, LDC, is misconstruing it with the application of the law 169(1)G and 2129 of the UPDF Act to section 169(2), which is general in application that gives 30 days. But Chiza Aaron, being an advocate, it puts him under a specific provision of 169G, 1G, and 2129 that gives a maximum sentence of 5 years.
So you are saying actually the court was lenient?
Absolutely. Okay. Actually, the court martial was lenient, considered his.
Do you speak to that in your reply and arguments?
Yes, my lord.
Thank you, sir. Yes.
My lord, I want to refer to Order 3 of the Supreme Court decision number 2 of 2021, Honorable Kabazibu, Attorney General versus Honorable Kabazibu. It said that this judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and sentences. You can
remove the word save and put except.
Except.
Except
where? Make it easier. Except where the conviction and sentences are being challenged in courts of law.
So, is it your view that the conviction and sentence of the person in court
were affirmed? Were affirmed by the Supreme Court that they carry legal basis and are effective.
They are effective for as long as they have not been challenged.
Yes. Now, and even the challenging, the Supreme Court did not dispose of the challenging. It says it did not, it means that where the challenge is ongoing, the trial can continue and be challenged.
So for me, what I'm raising at this point is this decision properly.
This matter arises from the conviction, it arises from a matter which is criminal in nature, and the right forum would have been the criminal division.
So who would have been the respondent if not the AG?
Uganda, the state of Uganda.
Represented by who?
Uganda would have gotten its representative. Uganda has many institutions which are in charge of its defense and prosecution.
So you are saying you are not so sure.
I'm very
It's
sure.
Uganda, but we don't know a particular agency, institution.
Your Lordship, Uganda is alive and it's known.
But this court is also Uganda.
Yes, my Lord.
Mm.
We have, for example, the office of the Director of Public
So
Prosecution.
that's what I was waiting for.
Yes, my Lord.
So that's the Director of Public Prosecution.
Because
Is she
the
in
order,
possession of this file? The subject of the conviction.
my Lord, she doesn't necessarily need to be in possession of this file. As long as a citizen of Uganda is aggrieved and has sued the state of Uganda, the fact that you have sued the state of Uganda, that file would be put to the attention of the office of the Director of Public Prosecution. Unless the applicant choose who should be, I think which I feel that in this particular case, he chose a preference of who should be